I had something interesting happen today during an estate planning consultation, and this isn't the first time this specific scenario has occurred during one of my consultations. And I also have a feeling that it happens maybe quite a bit. So I wanted to go over it in a video, just in case it could be helpful for others out there who are kind of going back and forth on what to do with their estate planning. So today I met with a wonderful gentleman, we'll call him Bob for purposes of this video. And Bob had a couple objectives or goals in mind for his estate planning. One, he was trying to do things as economically as possible. He wanted to spend, the least amount that he could, but still get the services that he wanted. A lot of people want that. I hear that all the time. There's nothing, shocking about that. Two, though, Bob was in a situation where he has a girlfriend, a partner who he's been with for about a decade, so about 10 years now. And he wanted to ensure that she does get something. He initially had a specific dollar amount in mind. And he wanted to know if he could, say, just trust his son. So he has a son, an adult son, to make this happen so that he could potentially meet this first goal of his, which is keeping cost down. Okay, so let's walk through this a little bit. In Bob's scenario, he owned a business, and that's where most of his assets are coming from. And they're like basically accounts receivable in the business. So liquid assets, cash that he receives in this business. So the business is the main thing here that we're looking at that has value, that when Bob passes away, assuming his girlfriend survives him and assuming his son survives him, that's where they're going to be receiving their inheritance. Now, to meet Bob's first objective, right, he was thinking, look, maybe I could just really simplify things, add my son to the business now, right, so that it doesn't go through probate, right? And then my son will be on the business, so he'll just automatically take it over when I pass away. And then I'll tell my son, hey, look, this is what I want to go to my girlfriend. Can you make that happen? So this may sound like a good idea. And I know lots of people who have put children or sometimes even friends on businesses as a way to avoid probate. But let's examine a couple of the pitfalls here. So first and foremost, the most important thing I always try to stress to people is just telling someone your wishes. In fact, even writing them down in a will, especially as it applies to property that is jointly owned, like a business, if you're adding someone to a business. These wishes written, even in a will, are not enforceable when someone else actually owns the asset. And that's exactly what would happen here. So if Bob were to add his son to this business, the business is an asset, he adds his son to the asset, the business, during his lifetime, then they become joint owners of this business. And in order to meet Bob's objective of the business passing directly to his son and not needing to go through probate, that means that his son then becomes 100% owner of the business when Bob passes away. Now, no matter where Bob writes his wishes of what he wants to give his girlfriend, whether it's in a business document, in a last will and testament, on a napkin, it doesn't matter. It's not enforceable in any of these documents, meaning it is ultimately always going to be up to his son whether or not he gives this gift to the girlfriend. You can trust your children to the maximum, and that is great, and I hope you do. But there's no way to guarantee or to legally enforce that wishes are met when someone owns an asset outright, which would happen in a case like this when the father and son own the business together during their lifetime for the purpose of passing it on to the son to avoid probate after the father passes away. So that's problem number one. Problem number two that a lot of people don't actually consider, and I got to really commend Bob because Bob brought this up on the call even before I did, is what happens if Bob adds his son to the business and they get into a dispute, right? This is a business that Bob has owned for many, many years by himself. So it's a limited liability company, meaning it doesn't require a lot of upkeep, doesn't require taking minutes every year. He's not accountable to anyone else in the business, right? So now you bring in this partner, which inevitably would and should require more business paperwork. Adding someone in, you want to lay down the ground rules. You want to make sure that the two of you agree on things, because son or not, relative or not, close friend or not, disputes can and often do arise in a business just sort of during everyday operations, right? Once you add someone to your business during your lifetime, now you have a partner. And everything that goes along with that, whether it's a relative or not, has the chance of occurring, right? So even if it's brought up like, hey, I'm just adding you to the business to avoid probate. Well, guess what? When you add someone to your business, there's legal implications, meaning they're now an owner. They now have rights in that business. There's also tax implications. These are things that people don't often think about either. Like, is this going to be considered a gift? Who's going to have to pay taxes? Is the son giving anything for the business? So there's complex tax implications sometimes. And the biggest thing that I think worries me the most, and I'm glad Bob caught this, is regardless of tax implications and regardless of trying to figure everything out and putting together the right documents in advance, if something goes wrong, and there's always that possibility, it would be great if it never occurred, but if something goes wrong while they're partners together, it could lead to an ugly, long, and very expensive dispute, and Bob could end up losing part or all of his business during that dispute. Now, that's obviously an extreme circumstance. Maybe he wouldn't lose the whole business, but he would most likely lose something. And this is something that he's worked on and created for his whole life. Really, the expense that you would save by not setting up something like a revocable living trust right now, because the trust right now is going to cost a little bit more than adding his son to the business, but it is absolutely not worth the headache and the possible expense down the road. Meaning what it could cost Bob if an actual business dispute did prop up, or potentially even in taxes, absolutely not worth it. So I'm bringing this up because I see this all the time where people get very inventive to try to, I don't want to pay for that revocable trust package. I want to, I don't think my stuff is that complicated. I think I can do it this way, or I'm just going to do it like this. And I trust this person. I see this all the time. And for many, many years, I've been doing this since 2001, I have seen these things go horribly wrong. So I'm putting out this video to stress before you do something like that, especially if it's giving away property, adding someone to a deed, adding someone to your business, adding someone to a financial account. Please consult with an attorney first, because there may be pitfalls that they have seen that you're not thinking of, and it's worth exploring before you make a decision whose consequences can be way worse and way more expensive than simply setting up different planning in advance. All right, so I hope this helps for anyone who needed to hear it. And if there's anyone out there who does need help with their estate plan and they're in Florida, please don't hesitate to contact us. We're at Cause Law Office, the non-stuffy attorneys, and the link is